Sorry once again for this delay from the planned schedule, but the discussion after Professor Decock's lecture was so good that we really didn't feel like interrupting it. There were very interesting arguments, so I think it will all be worth it. And we have one paper missing from this session, as I said already, so Yasemin Baykal will be unfortunately unable to attend. So hopefully we will make up for that delay. So opening session 5, the evolution of Sharia law in the modern age. Presenters here are Şehriban Imrak, Michał Tutaj, and Simo Ilić. I can see Michał is here. Şehriban and Simo, could you confirm your presence? Şehriban is here. I don't see Simo yet, but as he is the last, we don't, oh, here he is, he says so in the chat. So wonderful. Our first presenter then is Şehriban Imrak from Panthéon-Sorbonne, and her paper is Transformation of the Zina, the Invention of New Types of Zina. The floor is yours.
Hello, thank you very much. First, I want to share my screen. Just a second. Hello, everyone, and thank you all who made this conference possible. Before I delve into the details, I will give you a brief overview of what I'm going to talk about. As can be seen from the title of my research, it is about the historical transformation of the zina and the invention of its new types. Since there is a still great deal of confusion regarding the punishment, description, and translation of zina, a detailed analysis was conducted in this research to avoid such confusion. This study therefore consists of 3 sections: zina in the Quran, zina in the Islamic legal context, and zina in the Ottoman Kanunnamas. The aim of this research is to demonstrate the transformation of zina, its punishment in these 3 different sources, and the invention of new types of zina, especially in the context of the Ottoman Empire. At the same time, it will allow us to understand the transformation of Islamic jurisprudence and the gap between the prescription and the praxis in legal practice in general. Zina is defined as unlawful sexual intercourse between a man and a woman who are not married to one another, nor in a state of lawful concubinage based on ownership, the relationship between the owner and his female slave. So in the Quran, zina is included in the category of the had crimes, which are considered contrary to the rights of God, and therefore a punishment is laid down in the Quran for them. Now I'm passing to the zina in the Quran. There is a confusion between the had punishment and the death penalty, although had punishment does not mean capital punishment in all circumstances. In the Quran, only 2 surahs refers to zina. Surah Al-Isra is the first surah that refers to the zina. Verse 32 of this surah says, "Nor come near to adultery, for it is a shameful deed and an evil, opening the road to other evils." As demonstrated in this verse, in Islam, zina is perceived as something evil and should therefore be avoided. Surah Al-Nur is the second surah that deals with zina. The 8 verses of this surah contain clarifications not only regarding the punishment of zina, but also regarding the punishment of the slander of zina. As the second verse indicates, the punishment for zina in the Quran is 100 lashes without distinction between those are married and those are single. Verse 4 is crucially important because it demonstrates that zina is something that is not something that can be easily proven. Those who accuse a woman with zina are required to bring 4 witnesses who saw the sexual intercourse itself in order to consider it as zina. A fundamental point of this verse, another fundamental point of this verse is that the Quran makes no reference to the fact that witnesses are either required to be men or women. Verse 6, 7, and 8, verse 6, 7, 8, and 9 refer to cases in which husbands claim that their spouses have committed zina and have no witnesses other than themselves. According to these verses, in such cases, both accuser, they are generally husbands, and the accused, in general wives, are allowed to swear 5 times what is called liyan oaths, and if the wife rejects her husband's accusation and swears 5 times that her husband is lying, the wife will be spared a penalty for zina. Briefly, Quran does not specify the penalty of stoning or death, makes no distinction between married and unmarried, and does not specify the gender of the witnesses. Now I'm passing to the zina in the Islamic legal context. As this section will make clear, the prescription of zina in Islamic law and the prescription suggested by the Quran regarding zina are almost different. In the Islamic legal tradition, the testimony of women is not accepted, and punishment is stoning to death for married and 100 lashes for others. As can be seen easily here, the new method of punishment, stoning to death, is invented by male jurists and is treated by them as if it was a purely Islamic practice. A further important invention here is the masculinization of the witnesses. Given that Quran provides a gender-neutral system for witnesses, at least in the case of zina. The purpose here is not to romanticize or glorify Quran, because there are other problematic cases. For example, when 2 male witnesses required, but one of them is absent, it requires 1 man and two women. Woman is in fact regarded as half incomplete. The preference of male witnesses is in fact very similar to the gender hierarchy that Aristotle established in the form of the female is an incomplete male. In the Islamic legal tradition, the reason why men are preferred as witnesses is that women are considered intellectually inferior to men, and therefore women's testimony is not considered as reliable as men's testimony. Baber Janssen also makes an analogy between Sunni Muslim law and Islamic Aristotle's proportional justice, in which Aristotle states that, I'm quoting, justice is considered to mean equality. It does mean equality, but equality for those are equal and not for all. For example, while the male master has the right to have sexual relations with his female slave in accordance with his sexual needs or desire to have children, the female master has no right to have such relations with her master slave. This underlines the fact that the sexuality is also masculinized, as if only men had sexual needs or desires. So, how was it possible for them to do so easily? Who did it and why did they do it? All these inventions are indissolubly linked to the interests of the intelligentsia and the political authorities in power at that time. Indeed, what makes all this possible is in fact strongly related to what Khaled Abou al-Fadl describes as the despotism of the reader. Who were the readers? They at that time were mostly people with political power, jurists, and so forth, and they were all males, as you know. So it might be easier to understand why and how the stoning sentence for zina, the masculinization of witnesses, etc., were so easily integrated into Sharia law. In short, it can simply be understood that zina is handled very differently in the Islamic legal tradition, fiqh, than in the Quran. Now, with the Kanunname, we will have a better understanding of how this male reader authority has played an active role in changing and transforming the legal system. Now I'm passing to the zina in the Ottoman Kanunname. Apart from Islamic law in the Ottoman Empire, there are also codes called Kanunname. These are sultanic codes and they are more secular in comparison to Sharia. Of course, secularism should not be understood as secularism in the current sense of the term. In fact, there is a common understanding that in matters of sexuality, Kanunname is compatible with Sharia law, but this compatibility does not exist in the case of zina. The main change brought about by the Kanunname is that these forms of physical punishment have been almost entirely replaced by the monetary penalties in theory. However, as will be discussed in detail later, the new measures are not limited to the financial penalties alone. First of all, zina is no longer like the one in the Quran and the Sharia. According to Kanunname, as clause 9 shows, which can be seen from the screen, a sexual intercourse does not have to occur for it to be called zina, and it may even be sufficient to enter someone's home with the intent of committing zina in order for the accused to be sentenced for zina. So here I argue that zina is introduced in an entirely in a new form. In other words, it undergoes a redefinition. Kanunname introduced other alternative methods of punishment and appointed a new punitive body. A fundamental article of Kanunname on this point, or rather the article that I find most essential, is the Article 13. As you can see from the screen in this article, there is a consensus regarding the body and life of women between men of religion, imperial men, and men of the family. Why do I claim that there is a contract between these male authorities? Because here zina has been transformed from a crime against God to a crime against male family members, and for this reason they are allowed to kill the female family members. This is in fact a symptom of the crisis of masculinity, which is based on the total control of women. In this context, the question is therefore how to better control women. Contrary to the argument that Kanunname has abolished the death penalty, as we see from this article, that the death penalty is not abolished, it just changes form. Another very important clause of this Kanunname related to zina is the Article 14. As it can be seen from the screen, or if a person finds a stranger in his house, strikes him with a weapon and wounds him, provided he calls people to witness that he has wounded him in these circumstances, no capital or severe corporal punishment shall be demanded for him either. As you can see here, zina might be used as a pretext to kill or punish someone in such cases quite easily. The two other notable articles of the Kanunname that are worth examining are Article 16 and 17. As you can see from the screen, what Article 16 and 17 of the Kanunname have in common is that they both simply make assumptions that women are guilty of zina. They both start with if a woman is spoken ill of as having secret or illicit relations. This implies that no direct sexual intercourse is required here and that only a rumor or a slander can be sufficient to punish a woman for zina. It is indeed these practices that generate gossip, slander, and violence against women. At the same time, with these articles, the responsibility of moral policing and moral protection is systematically extended from the male members of the family to the neighbors or whoever is in the same vicinity in general. Now I will try to summarize and conclude my study here. To summarize, the purpose of this study was to demonstrate a historical transformation of zina that continues even today and has been used as an excuse to justify violence against women and to criminalize women's sexuality. As I explained in detail earlier, the first deviation from the Quran regarding zina begins with the actors of Islamic legal tradition and political authorities. The first deviation was the insertion of the punishment of stoning to death for the married, which was a pre-Islamic practice, into the Sharia and making it look like an Islamic practice. And the second was the masculinization of the four witnesses, which was obligatory for the zina. New forms of zina and new punishments were invented under the Kanunname. Male members were appointed as the new mechanism of punishment for female family members who were alleged to have committed zina. So, why is this research important and what kinds of conclusions can be drawn from it? All of these are very significant and can be seen as a longue durée of the legalization of femicide and violence against women. And the fact that Turkey withdrew last week from the Istanbul Convention, which aims to prevent violence against women, is a clear indication that this legalization process is still happening. So, men of the state, men of the religion, and men of the family continue to act hand in hand against women and LGBTI+. It is therefore more important than ever, and more works need to be done. And thank you for your attention, and I will be happy to answer your question.
Thank you very much, Şehriban. I'm sure there will be questions in the discussion, but we are moving on to the second presentation now. As Yasmin is unable to attend, our next presenter is Michał Tutaj with his paper, Intestate Succession in Turkey, Law Inspired by Religion or Still Based on its Secular Heritage.
Hey, thank you very much. Can you hear me well? Okay.
Yes.
Okay, great, thank you. First, lots of thanks for giving me the opportunity to participate in this brilliant initiative. Well, this is really pity that we cannot meet face-to-face in Belgrade. I visited Belgrade a couple of years ago, and I really hoped for a revisit, so that's a pity. Well, I hope for the next year. Well, that's my first tie with Belgrade, and another tie with Belgrade is Alan Watson. As we could listen to at the beginning of the conference, Alan Watson had some special relationship with your university. My tie with Watson is a bit more indirect, let's say. He's well known for legal transplants, although he did not coin this term, as I know, this term was coined by Jeremy Bentham, and then it was used by Walton also. But we must admit that Alan Watson is well known for his legal transplants, maybe not theory, but conception. And legal transplants are of my primary interest due to inter alia my PhD thesis and what is interesting for me in a comparative law. Well, so finally, after this little intro, I'd like to move to the subject of my presentation. Well, everyone interested in legal transplants probably knows that Turkey is usually presented as one of the most notable examples of legal transplants. This is due to its legislative activity after the First World War, after the collapse of the Ottoman Empire, and at the time, Turkey transferred many legal codes from other countries, from Italy, from Germany, from Switzerland, and Switzerland is the most important for me and for this presentation. In many cases, these borrowings were rather specific. Let's say, well, usually when we think about the reception of foreign law, like the reception, let's say, of Roman law in medieval times in Europe, we think about huge efforts of jurisprudence and of case law, of courts to somehow fit the foreign law into the local legal system. And local legal system, local commerce, local customs, local morality, and so on. The example of Turkey after the First World War is a bit different. The reception was carried out differently usually. To much extent, the codes were just translated into Turkish from the, let's say, French or German language, and promulgated without introducing many adjustments. I might admit that, well, it's not fair to say that Turks just translated, for example, the Swiss Civil Code, although it's often used in many scholar papers. But I think it's not only translation. There's an interesting article on that there were some discrepancies that were, well, vital for functioning some institutions. But let's say, well, this reception was specific, as I said. Still, it was in big parts it was just a translation. So to much extent, this just transferring foreign norms into local system it was intentional. I mean, this legal activity was treated and was perceived as a measure to introduce revolution, to introduce rapid modernization of Turkey and rapid withdrawal from its Ottoman and Islamic past. For many, it was and it still is astonishing, mainly because of the common belief that law is the reflection of religion, of morality, of customs, and so on, and of tradition. And we must admit that the religion and tradition in Turkey and in Switzerland, especially after the First World War, were significantly different. Well, it was completely different societies, let's say. Nevertheless, the Swiss ZGB, the Swiss Civil Code, was just transplanted from Switzerland to Turkey. This is why the Turkish example is sometimes perceived as a simple denial of this conception, of this traditional conception taken from Montesquieu and Savigny, that law is just the reflection of social factors and so on. And it's used by many authors to say that the thesis, the conception, the law is separated from this, let's say, social factor is true, and this idea is the focal point of conception of legal transplants. And final words on legal transplants, and others claimed that such experiment must be unsuccessful in longer term, and that local authorities, society will reject the transplantation, will slowly or rapidly change the law and adjust it to other factors, mainly religion. In my presentation, I would like to verify this conception in the area of succession law in Turkey. And I will be speaking mainly about the current Turkish law, although I must admit that I'm always a bit odd when I speak about foreign law in the presence of people for whom this law is not foreign. As I suppose we have some Turkish speakers here. But this is, however, a constant burden of comparative lawyers, I must admit. And on my topic, the succession law is chosen intentionally. I mean, generally speaking, family and succession law is often perceived as a part of the family law. And those branches of law are believed to be the most influenced by local morality, religion, and customs. It's not surprised that when EU tried to harmonize the civil codes to some extent in the EU, it started to work on draft common framework of reference that was regulating mainly contract law. Intestate succession and the closely linked issue of reserved portion remain focal in the field as those issues allow to verify whether the system is focused on reserving estate for family or giving freedom to testator. So that's why I decided to speak a few words on this point. So I would like to check if there is some impact on Sharia on succession law in Turkey. This is more important in the context of religion here because the religion is playing more and more important role in Turkey. Well, I think it's now playing more important role in Turkey than it was, let's say, 20 years ago. I think that is uncontroversial when we take a look at the political agenda of current government of Turkey. So, but checking if any religion pattern appear in Turkey's current civil code may give us a tip of whether the Turkish legal transplant works or whether it's somehow affected by dominating religion in Turkey. This may be interesting insight on the law and religion relationship. Yeah, but before talking about Turkey, let's say a couple of words on succession law in Islam, because we need to have a sort of a point of reference here. Well, it's hard to have this point of reference, I meant to sneeze, because the Sharia rules on inheritance and succession are very complex and varies between legal schools and local traditions. But well, let's say that the main principle is that only 2/3 of estate is reserved for intestate succession, whereas only 1/3 can be disposed in a last will testament. The disposition is not fully free, as the last will cannot change the proportions of succession of estate granted for family members. So we cannot, let's say, give, for example, our favorite daughter more than others, and so on. And among successors, among these intestate successors, we can distinguish the ones mentioned in Quran and those unmentioned. For those mentioned, the rules of inheritance of these reserved portions are very strict and complex. But just let's remember that many family members are entitled. There are special portion for parents, for sisters, for daughters, for a spouse, and so on. Each one in specific portion gets its reserved portion depending on how many and to which heirs lived. For example, if there is no sons, the only daughter could receive up to 1/2 of the reserved portion, whereas if there are more daughters, they may be entitled to 2/3. What left from the estate belonged to from the state after giving some portions to this Quran heirs was belonged to male heirs unmentioned in Quran. So we can call them kind of residual heirs. Among residual heirs, there were tiers, and the first tier were male descendants. Therefore, the main pattern to remember are that the estate is dispersed between multiple family members, and that the reserved portion, I mean the portion that is reserved for intestate heirs, is quite big, at least from my perspective. So let's check if this pattern can be somehow identified in the Turkish civil law. First, let's take a look at the core of intestate succession, the tiers of heirs. The Turkish law, the Turkish civil law, the Turkish civil law in its section on intestate succession recognizes 4 tiers of heirs. Higher tier heirs receive the whole estate before the lower tier. I think it's the similar solution as in the majority of, or almost all, European civil codes. But so I think that everyone just know how it works. For example, children are somehow, well, just get the estate before the, let's say, grandparents and so on. So the classes, these 4 classes are as follows. In the first class, we have descendants. In the second class, we have parents and parents' descendants, so the brother or sister of the deceased person. In the first year, we have grandparents and their descendants. In the fourth, the state. The rules remain the same in the current civil code of Turkey of 2002 as in older civil code, because Turkey changed its civil code in year 2002, but it was rather a kind of modification, not the revolution, let's say. And it's the same as in the, let's say, original Swiss civil code. So I would think this pattern is received here, that the Turkish law goes on its way, that there is no, we can't see at this stage an important impact of religion rules on the civil regulation of interstate succession. There are also some special rules regarding to spouse, and the rules are maybe not complex, but I will not go into all details. But the rule is that if there is a spouse, she or he can inherit 1/4 of the intestate of this estate if she or he inherits with heirs from first year. Comparing to the Swiss civil code, it's less, because in Switzerland we have 1/2. The spouse can inherit 1/2 of if she or he inherits with the tier 2. It's less than in Switzerland, because there is 3/4. If there is a inheritance with the third class, the third tier, in Turkey the spouse receives 3/4 of the estate, whereas in Switzerland, if there is an inheritance with the heirs of tier 3 or 4, the spouse receives, or partner receives, the full estate. So in Turkey, the full estate is received inherited by the spouse only if he or she inherits together with the 4-tier heir, so the state. So I know well, maybe it's try to imagine it when I just speak about, and I do not show the numbers, but the general conclusion from this section is that the family position is a bit stronger in Turkey in the relation of the position of the spouse. I mean, the spouse receives less portion than under civil code. One may suggest that it can. One may say that it may suggest some kind of traditionalism, some kind of worse position of the spouse, which is always someone external for the family than the position of the family. But I think that is just sticking to the previous code provisions, because those provisions were not changed between 20th of the 20th century and the latest change of the civil code. So I think it shouldn't give us too far-reaching grounds for too far-reaching conclusions. But the conclusion from this section for me is that the law does not try to reflect any guidelines of Sharia. It keeps tracks of the Swiss civil code, doesn't try to change any tiers of heirs, and does not complicate rules of interstate succession. There are some discrepancies related to the position of spouse, but it's, as I said, it's not the ground for me to far-reaching conclusions. And that's the first portion, the first section on the interstate succession, let's say sensu stricto, but the interstate succession is closely linked to the issue of reserved portion. Reserved portion is the portion of the estate which cannot be disposed by last will. I mean, it's the portion that when even with the deceased person, a testator prepares a testament and last will, he must leave some part of estate for his family. And well, in Rome it was called pars legitima or portia debita, but well, the system here is a bit different, let's say, in Roman law, but not go into these details. But the issue of reserved portion is closely linked to the intestate succession, because it shows us how the, let's say, controversy, how dispute between the freedom of last will and freedom of testator and the, let's say, kind of solidarity among the family, this tension, how is it resolved? And when we say when we take a look at the Turkish solutions, we can see that the amount of reserved portion changed between the first civil code and the current civil code. And for example, for now, the reserved portion for descendants is 1/2, whereas in case of the previous code, it is a decrease from 3/4. If there is when we say about the reserved portion for parents, it's 1/4, and it's also decreased from 1/2. And there is no reserved portion for siblings now. It was removed in 2007. Before, there was also a kind of reserved portion for siblings. What is important that those numbers are lower than in the case of the Swiss Civil Code, because we can see that in the Swiss Civil Code we have 3/4 for descendants and 1/2 for parents. So it's like in the old Turkish Civil Code. So the conclusion is that there is more freedom for the testator, less must be left for the members of the family. He or she can dispose the estate more freely. But this conclusion is also only partial, because when we take a look at the position of the spouse now in the Turkish Civil Code, her or his position is better than it was before. Now, if there are parents and if there are descendants, the spouse receives the full portion of this reserved portion. I mean, so she or he receives as much as under intestate succession. In other situations, when there are other, let's say, heirs living, she or he receives only 3/4. It's much more complex. It's more complex than in Switzerland, because there is always a kind of universal general rule that the spouse reserved portion is only 1/2. So the conclusion is that the position of spouse is improved when we compare it to the position of testator. So when we look at all these issues I tried to draw, we can say that there is no common pattern. I mean, in case of intestate succession, we can say about a bit better position of the family. When we take a look at the reserved portion, we can say a kind of benefit for the testator. And when we take a look at the position of the spouse in the case of reserved portion issue, we can see that she or he her position is better. So what are conclusions? Well, my first conclusion, there is no stable pattern. I think if we take a look at different solutions, we see that sometimes Turkish law is more favorable for testator, sometimes for family, sometimes for the spouse. So there is no common pattern. There is no, there is no pattern similar to the Sharia, to the Islam law. So I think that for me, the main conclusion from this exploration is that the suggestions that law must reflect external factors like religion or tradition are false in this case. I know that it's only the one branch of law, but I think it's important branch of law. Nothing suggests that in the area of inheritance, which is really important from the perspective of society, Sharia rules play any role. In particular, we do not see any pattern similar to Sharia, like dispersion of estate among many family members, and the portion of the share of the estate which is disposable for the testator is not much different from the portion which is available for in other civil codes, and it's also similar to the amount possible under Sharia. So here I think we generally cannot see any general conclusion, and well, maybe the only conclusion is that the Islam law and many civil laws are quite similar in the area of the reserved portion for the state earth. So, but from the wider perspective, for me, this analysis supports the Watson's view on legal transplant. He insisted that legal transplants follow their own path. They do not take a look. Well, they are not influenced either by original legal system, Swiss in the case, or social or religious norms, and the impact of such norms is highly limited. There is a kind of important separation between the let's say lawyers, the society, and the social factors. So I think that this case, the case of intestate succession and reserved person in Turkey, strongly supports this conception of legal transplants as presented and developed by Alan Watson. Thank you very much for your attention, and I will be very happy to answer your questions in the discussion section. Thank you.
Thank you very much, Michał. And we're moving on to the last paper in this session, moving on to the west towards Europe, but staying within bounds of Sharia law. So Simo Ilić from our University of Belgrade Faculty of Law with his paper, Sharia Law in the Kingdom of Yugoslavia. Simo, go ahead.
Can I share a file or I have to share a screen?
You can share a concrete application, so you don't have to share the whole screen. Just make sure your PowerPoint or whatever it is already open. And then when you click share, you'll have all your open apps as options, and click on just sharing the PowerPoint and not the entire screen.
Okay. So here I am. Let's start the timer. And okay, hello to everyone. The topic is Sharia law in the Kingdom of Yugoslavia. And first thing I want to say about it is where the Muslim minority in Yugoslavia lived. It was concentrated in territories that were recently liberated from Ottoman rule, and that was territories of southern Serbia, Macedonia, Bosnia and Herzegovina, and some parts of Montenegro. In this area, Ottoman rule lasted longer than in others, and it was in Bosnia case until 1878 when it was occupied by Austro-Hungarian Empire. In southern Serbia, it was until 1878 or 1913 when it was liberated in Serbo-Turkish War or Balkan Wars. And in this area, it is interesting, and it have to be said, the Western culture wasn't familiar in these areas. They lived Turkish style of life. They were very conservative about changing these private lifestyles. They accepted some Western influence in trade sector, like capitalism, like business and things like that. But about private life, they stayed very conservative, and they didn't want to adopt some human rights and things like that. So let's see. This is the left is the chart where is displayed where Muslims lived. So it's the dark green area. On the right, you can see chart 2, and it's also the 1878 piece of chart and 1913 piece of chart. So these were the areas, and there was in Yugoslavia there was around 1.3 million Muslims in population. So why they adopted Sharia law? The first thing is the international obligation. Yugoslav agreement with Austria, signed in Saint-Germain in 1990. The one provision obliged Yugoslavia to regulate personal, family, and inheritance matters of Muslim according to their customs. So as you can see, the Sharia law wasn't obligatory by this provision. This provision left some possibility for reform, and it's also left some possibility for alternative application of civil law. For example, if some Muslim was liberal and he didn't want to be obliged to Sharia law, he could opt out for civil law. But in Yugoslav political life, there was Yugoslav Muslim Organization, which was a political party which represented Muslim minority, and Sharia law application was one of key elements in their political program. So when Yugoslav constitution was about to be adopted, they conditioned their vote for constitution by making Sharia law mandatory for Muslim minority, and they got it. So in first and second Yugoslav constitution, there was provision about Sharia courts and Sharia law application for Muslim in family and inheritance matters. And there was act in 1929 which executed this provision. So Sharia law courts were branches of regular state courts, and these norms didn't left space for reforms or alternative application of civil law. So let's see some problems about Sharia law application in democratic country and multi-ethnic and multi-religious country in the beginning of 20th century. The problem one, it was particular law, and it was against democratic and civil law values. So in modern states, there is values that law should be equal for everyone and that religion shouldn't make difference between citizens. But this was problem, and there was huge debate. Do we want Sharia law or abolished or not? The defenders of Sharia law defended it as it was minorities' right, Muslim minority right, and they wanted, so we have to give them. And about this, it made a lot of law barriers between citizens of the same states. The best example is interreligious marriages, which were firstly very it was allowed between Muslim men and Christian and Jewish women, and later in 1938 it was prohibited for Muslim men and Jewish and Christian women too. So it was completely forbidden. The problem was there was no opt-out. For example, in French model, which had France had the same international obligation, but its application was okay in Algeria. They had they applied the Sharia law, but they made some opt-out choice. So if some liberal Muslim didn't want to be obliged to Sharia law, they could opt out for civil law, and it was okay, but that wasn't possible under Yugoslav model, and it made unification and secularization of marriage law harder, because you know, if you gave a religious law to the Muslim, the Christians, the Orthodox and Catholics wanted same for them too. So that was problem, first problem. problem. A second problem was that law was outdated and inappropriate for that situation. It was contradicted with many human rights and freedoms, and it wasn't compatible with modern way of life. So here is some examples. First is religious conversion from Islam, and the consequences of that were losing of marriage, inheritance rights, child custody. That is a severe thing, but in some modern democratic country, you have to have freedom of religion, but this norm of Sharia clearly didn't allow that. The second problem was Sharia law prohibited adoption of legal children. The third problem was inferior position of women. And there are a few aspects of this. First is the woman didn't have freedom of movement. So if she wanted to go out from home, or if she wanted to receive a visit, she had to ask her husband, can I go out, or can my friend came here? So that was very bad. Second thing was polygamy, but it wasn't a big issue in Yugoslav territory because there were a very small amount of polygamy marriages. Third thing is divorce, and this is maybe the worst one. In Sharia law, the husband had talq, right? The talq means to release, and it was the husband's right to dissolve the marriage by simply announcing to his wife that he lets her go. So he can say to her, okay, you're not my wife longer, you can go, and his marriage will be dissolved. And on the other hand, the woman could get divorced only through court and in very few situations. And all these situations were based on lack of alimentations or a husband's impotence. So woman didn't have the right to divorce in a case of abuse. If she wanted to get divorced from a violent husband, she had to convert to another religion, and that wasn't a great thing, because if she converted to other religion, she would lose things I mentioned earlier. And Mehr, which was designed to be insurance for women in case of divorce, in Yugoslav state, it wasn't a big deal because it was regarded as religious custom and its value was really low. It was symbolic. So Muslim woman who would be released was in very, very bad material state because she lost her finance. The third problem was evasion of law, because the Muslim marriage law was, how to say, less rigid. Many Christians abused conversion to Islam to evade Christian marriage rules, and so this is there are situations where they abuse it. Men use abused conversion to Islam to use talq to divorce their marriage or to marry a second wife. And women also abused conversion to Islam because if she converted to Islam and his husband refused to, then their marriage would be resolved because the marriage between Muslim women and non-Muslim men was prohibited by Sharia law. So this, I must say, there were not many people who were abusing these rules, and that wasn't changing numbers between religions. But Christian religious community were angry because Muslim community helped their people cheat them, and they were really angry. So there was a big backlash about this abuse of law. And the side effect of this rule is interesting. It helps some Jewish women from Nazi Germany to escape to Yugoslavia and to get Yugoslav citizenship by marrying a Muslim, getting citizenship, and then by talk divorcing it. So that was time when Germans immigrated to Serbia. It was interesting to see. Last thing, as we can see, the reforms were needed, and there were some proposal, but they minor reforms were proposed. For example, they proposed prohibiting polygamy, which wasn't an issue, as I said, and they proposed limiting talc divorce, which was very needed. They also proposed preventing abuse of conversion to Islam. But some judges even judged contra legem in attempt to reduce tension between the religious communities, but they were in minority. Also, it was really interesting that in this period, the major Muslim countries in the world, like Egypt and Turkey, had some reforms of their marriage law, and they had some secularization, but Yugoslav Muslims refused to follow their example. So there were no reforms. Islamic religious community rejected all proposals. They stayed strict on implementing Sharia law, and they even pushed it more conservative than Sharia law originally was. For example, they banned all interreligious marriages, which wasn't Sharia law practice. So at the end, it was complicated situation, but in first Yugoslav state, the solution wasn't found. So that would be it for me.
Thank you very much, Simo. And now I'm opening the discussion. Does anyone have questions for our presenters? Once again, feel free to either just turn your microphone on and speak up, or if you can't, type your question in the chat. If for some reason you can't chat to everyone, feel free to chat to me and I will read the question out loud.
If I can have a question, sorry for not raising my hand, but I do not see the option to raise.
Absolutely.
To raise the hand. I have a question for Şehriban on the first presentation. There was a passage on the Ottoman Criminal Code. I just would like to ask which criminal code you were talking about. Well, sorry, I could miss it, but was it a kind of criminal code from the Tanzimat period or something earlier? It's my first question, and the second question is, was the penalty of stoning also for men? I mean, you were talking about women, but I just like to know if the stoning in the case of Zena was also a potential penalty for men. Thank you.
Thank you very much for the questions. They are both very important, and sorry, because of the time limit, I couldn't explain which code it is. It is actually a 16th century code which is prepared during the reign of the Sultan Süleyman, the legislator, as may you know, and it's a 16th century code. But we can see this code applied by the later sultans as well. For the second question, stoning is implemented for both male and female, but it doesn't written in the Quran. It's later added by the Muslim jurists, and I hope I answered your questions.
Okay, thank you. Clear now.
We have a question from Victoria.
Yes, thank you. I'm trying just to lower my hand now, but I'm okay. That's it. I have a question to Michał. If I understood you correctly, you said that the evolution of the Turkish law of succession included like a gradual diminution of this reserved portion. So could we assume that it was just becoming, let's say, more and more liberal, like more and more favorable to the for the testator? Can we claim so?
Well, to some extent, yes, but to be honest, I cannot say that the, let's say, universal pattern of change in the latest changes of the civil code. I mean, the position of the testator is improved in the case of when we take a look at the amount of reserved portion for family members other than spouse. But when we take a look at the position of the testator towards the spouse, his position is even worse. And so I don't think that we can say that it's becoming more liberal. I mean that it's just changing, and that's why I think it's the general conception that the law is somehow that the transplanted law is somehow not influenced by other factors. I mean, the factor of the previous civil code and the factors of the social factors is true, because it just goes its own track, which is absolutely different, and we cannot just say, well, it's inspired by religion, or well, it's inspired by the history, or well, it's inspired by the Swiss solution. So I think that it's hard on the basis of the succession law to say that we have an universal pattern of change, which it could be religious or liberal. It's just changing in its own track.
Thank you very much.
We have a question from Bachas now, and after that one from Sofia in the chat.
Yeah, hello everyone. First of all, my question will be for Şehriban. And before the question, I really congratulate you on your comprehensive and comparative work. It's really nice to see such studies. And the question is, it is generally discussed in academia not as a new type of zina, but as an extension of the scope of zina. And why do you prefer to refer to it as the invention of the new type of zina? And what is your motive for that? Thank you.
Yeah, thank you very much. It's a really important question, and yeah, as you said, in academia, they prefer to use the extension of the scope of zina, but let me check it, especially with the article, for example, 16 and 17 of the Kanunname, for example. I said, indeed, without exaggeration, the fact that a man and a woman who do not know each other are standing in the same place, breathing the same air, can almost be considered zina according to Kanunname. So an approach like an extension of the scope of zina seems to me something of a romanticization of an invention that leaves a woman so vulnerable and how to say, justify violence against them because the expansion of the scope of zina is nothing more than what has been invented by the male authorities and male perpetrators to protect themselves and their brothers. But how to say, we therefore need a historiography that no longer speaks with the language of the perpetrator, but one that speaks with the language of the victims, the vulnerable, and the silenced. And my motive, how to say, the force that urges me to do that is the there are certain things in historiography, they just say, oh, no, you should not say this, you cannot say this and that. So I think we should, we need a historiography in which we can talk about everything. For example, always we criticize slavery, we criticize genocide, we criticize Holocaust. If we can say Holocaust, genocide, we should say the invention of new types of zina, because as you see with the Kanunname, almost everything is considered zina. So yeah, I hope I answered your question.
Yeah, thank you very much. I think I got your idea.
Thank you. So we have a question in chat from Sofia to Michał. She says, since you mentioned your interest in legal transplants, I wanted to hear your opinion on the necessity of giving a part of your property to the intestate heirs, which appears in many legal systems during the history. Maybe one of the more famous examples would be the lex falsivia in the 1/4 of property in Roman law, which had to be left for the intestate heir, even though there were many other such cases. I wanted to hear your opinion on these similarities, and do you think they are the results of legal transplanting or not?
Okay, thank you very much for the question. That's interesting, and to be honest, I think that legal transplants are not crucial when we think about the idea, the solution of of having such a reserved portion for some heirs or for some family or someone else. As we could see in Islam, for example, in Sharia, the idea is also present there. I mean, there is only 1/3 that is disposable for others. So for me, the general and well, the German laws, I mean, not the law of Germany, but Germanic laws as simultaneous to let's say Roman law at some level. Well, the idea of having special portion for family is rather universal. I think that is the part of the general anthropology and the thinking that, well, what is yours should be also the part. Your family should also have a part in your, let's say, estate. What legal transplants, let's say, influence is is rather the technical way how we think about legitimate portion, the pars legitima. I mean, when we take a look at the Europe and the world, we know that there are generally two systems of reserved portion. One, which is that the reserved portion is a kind of, and it is the French system, let's say, when the reserved portion is the portion just of the estate, and the German system, the system where the reserved portion is rather a kind of claimable. It's just claimable. I think it's the claim for paying you the legitimate portion, but it's not the separate part of your estate. So yeah, the legal transplants have some impact, but not on the introduction of the idea of having some portion for your family or relatives, but it's legal transplants affect whether we have in Turkey the system, the Swiss French system of reserved person as the part of the estate, or whether we have the let's say more German related system of reserved person as a claimable. I hope that it addresses your question.
Thank you. If Sophia sends anything else, I will read it. Yes, she says, thank you. It was a great answer. And if I may also add, if there are no other questions, I'd have one brief question for each presenter. For Şehriban, you mentioned that the Kanunnama gave the husband a permission to kill adulterers. Do you think that was a transplant because we have that permission in Greek law and Roman law, so it spread throughout Europe? So do you think that was actually a Western influence on Turkish law? For Michał, have you maybe considered in the context of inheritance law in Turkey, the difference in marriage law, because as far as I know, the Turkish Civil Code raised the minimum age for marriage quite a lot. I think it was 9 years for girls and 11 for boys, and they raised it to 15 and 17. That's quite a difference. And then, of course, there were illegal, traditionally made marriages, and those children were illegitimate children, and that also had consequences in inheritance law. And the last question, the question for Simo, you mentioned that the Islamic community in Yugoslavia was against all proposed changes, but as we know, there was a project of a relatively uniform civil code, the so-called Predosnova, 4 bases of the Yugoslav civil code that was never passed. But what do you think what the consequences would have been had it been passed, and what would have been the responses from the Muslim community? So thank you all.
I'm sorry, I think I couldn't understand the question because of the internet connection. If you could just repeat it and yeah.
I'm very sorry, you should have said earlier.
That's my problem as well. I just write you down. I hear many noises in the background. That's why I barely could hear you.
Can you hear me better now? Or should...
Oh, I can hear you perfectly.
Okay, Şehriban can at least. So do you think the permission for a husband to kill an adulterous wife and her lover was a transplant from Western law, because we have similar norms in Greek law and Roman law, and they continue throughout the Middle Ages? And while you answer, I'll type.
Yeah, thank you very much. Actually, yeah, because due to the time limit, I couldn't give many details about it. It's not only a case, it's not an only case which is seen in the Islamic geography. Yeah, there are the same problems, for example, at the same time period in Italy and in France as well. So for the 16th century code, I'm not quite sure, but for the later periods, yes, we can say there is a great influence from the Western. For example, in 19th century, we see the Ottoman Empire adopted the Napoleon Code Napoleon. So, and after that, as our next presenter, I'm sorry, I just forget the name, Michał explained there are other influences as well. But for 16th century, I will think about it. I'm not sure. Yeah, for the later period, yes. For 19th century, especially. I hope I explain. I don't know.
I think you did. Thank you very much. So I typed my question to Michał. So either you or Simo. Simo, did you hear my question?
Yeah.
Okay.
Thank you. I can see your question. This is interesting perspective. I know that the age of the age of marriage has changed significantly there, and generally it was one of the there was some criticism of the Turkish civil code of the 1926 that the age of marriage was raised, but not as much as could. But I think I must think over your proposition. But to be honest, the issue of illegitimate children now is not the issue in practice. I mean, the law recognizes the rise of illegitimate children in Turkey at the same position as of the legitimate children. I mean, it was not their position was not equal in the past, but after few legislative changes, and I think also the ruling of the Constitutional Court, the legitimate children position is now equal to legitimate children, and I think it's from historical point of view, it could be taken into account when we think about inheritance law, but for now it doesn't play a role, I think. More interesting point for point of, let's say, interrelation between marriage law and general inheritance law. Maybe marriage law, but the how marriages work in practice, and that in practice, as I could hear from my Turkish mates, that in practice not all, let's say, partnerships are formalized, and that there are also many situations when there is no civil law, and although there is a kind of religious, there's no civil marriage, although there is a religious marriage, and that's interesting, let's say, a point of view also. But for now, but for now, the case of legitimate children is not crucial, I think.
Okay, yes, sorry, I should have specified I meant when the code was passed, but I understand your general outlook. And Simo, and with that we'll conclude the session.
Can you hear me? I think if the Unified Civil Codes were enacted, that wouldn't change anything, because in the Constitution and in Sharia law courts and Sharia law court judges act, it was clear that a civil code won't be applied to a Muslim minority in marriage, family, and inheritance matters. So that wouldn't change anything, but the Sharia code Sharia law existence in Yugoslav country made it harder to get Unified Civil Code passed, because it made it harder to secularize marriage law, and that was a problem. I might say that there was some problem with there was many problems with Sharia law, and it needed reform, but the Islamic community was clear that the country, the Sharia law won't be reformed by, I don't know, parliament or some government or states authorities, that if the Sharia law was going to be reformed, it should be reformed by Islamic community, and they never did some reform. So that's it.
Thank you very much. Thank you all once again for very interesting presentations. I hope you'll all send your papers for publication in the Herald of Legal History. And that concludes the English sessions for today. The last session is in Serbian, so we say goodbye to our non-Serbian speaking foreign friends, and hopefully we'll see you tomorrow. We also have an interesting keynote lecture by Professor Pietro Lojakono and 2 more English sessions on contemporary history. So goodbye for now, and as for the Serbian speakers, let's make a break till 3:20, and then we proceed with the last session for today.
Thank you very much for this opportunity.
Thank you for the leading.
Goodbye.
Goodbye.